So I'm going to ask little brother Pettis to help me, and maybe John, and we'll just start off by something that's very important, and it deals with the internet. So we'll go right here. And we're going to ask, where is the cloud? You hear that every day, don't you? Where is the cloud? And it's something everybody uses. Some are using it right now, the cloud. Where is it?
It's there.
Okay, I'm going to ask John back here to start reading for us.
A Minneapolis couple decided to go to Florida to thaw out during a particularly icy winter. They planned to stay at the same hotel where they spent their honeymoon 20 years before. Because of their hectic schedules, it was difficult to coordinate their travel.
I'm going to ask you to read me one more page.
So the husband left Minneapolis and flew to Florida on Friday, and his wife was flying down the following day. The husband checked into the hotel, and unlike 3 years ago, there was a computer with free internet in his room, and he decided to send an email to his wife.
Okay, little brother Pettis, help me with this one. You got to talk real loud so we'll hear.
However, he accidentally left out one letter in her email address, and without noticing his error, he sent the email to the wrong address.
Okay, and now Mom Pettis. Hannah.
Meanwhile, somewhere in Houston, a widow had just returned home from her husband's funeral. He was a prominent pastor who was called home after suffering a heart attack.
Okay, and I'm going to ask John again.
The widow decided to check her email, expecting messages from relatives and friends.
Another one, John.
After reading the first message, she screamed and then fainted. The widow's son rushed into the room and found his mother on the floor, then glanced up and saw the computer screen, which read,
Hannah.
To my loving wife, Friday, February 4th, 2011. I have arrived.
Keep going, Hannah.
Dearest love, I know you're surprised to hear from me. They have computers here now, and you are allowed to send emails to your loved ones. I have just arrived and have been checked in.
John.
I see that everything has been prepared for your arrival. And look forward to seeing you then.
Go ahead, John.
Oh, hope your journey is as uneventful as mine was. Be serious on it.
Okay. So where is the internet?
Everywhere.
Okay, and the reason I use this is because I'm a probate lawyer. I do a lot of probate, and I do a lot of wills and estates. And I see people go to the internet all the time to make their own wills. Now, let me ask a question. How many of you in here would go on YouTube to find out how to take out your gallstones? I mean, there's a video on that, you know?
Oh, yeah.
How about when you had your baby? Would you like to have
Deliver
Brother
via
Chaffin do
YouTube?
that? He
No,
said, come on,
thanks.
Brother Chaffin. No, we don't want Brother Chaffin anywhere around here, right? Okay. And let me tell you what happens. You can do your own will. There's the law on the internet. There's tons of law. You might be making your will under New Zealand law that you didn't read the little predicate to it. And you might be doing it that doesn't conform to the state that you're in. The law that applies to your wills and estates is the law of the state you're living in, not the federal law. There's no Trump law in this. I mean, not the okay. Your state is dictated by the law of the state where it's made. Now, if you make a will in Texas and you move to New Mexico later, the law of the state where you made the will applies to that will. That's because in the Constitution, there's a thing called full faith and credit. The United States Constitution did an e pluribus unum. Does anybody know what that means in Latin? It's on your dollar bill. E pluribus unum. Pluribus, out of many, unum, one. Out of many, one. So there's all the states have combined now to become one union, and the laws of one state will apply to other states if it deals with domestic things like family cases, wills, trust, estate, things of that nature. So if you make your will under Texas law, it's going to be okay in Michigan if you move. If you make your will under Michigan law while you're in Texas, it might not apply, because the thing is, it's where you are when you're making the document that creates the jurisdiction as to what applies, but it still might apply. Now, when I'm doing my own gallbladder examination and excising, I want to make sure, it doesn't matter what state you're in, but I'll be in the state of confusion if I did that. Okay, so we're going to be talking today about the basic documents that are needed in the estate plan. And the reason I did the little internet thing was because I see so many wills that people create themselves, and then they're no good. Like, I had a will not too long ago where a lady went on the internet and got the Texas form. She found Texas forms, made the will. It was perfect under the format. However, she signed it as the testatrix, and she signed it as a witness. She witnessed her own will. Is that valid?
No.
No, it's not valid. And what about this? You can do a holographic will. You know that? That's wholly in the handwriting of yourself. You can do that. But are you going to be precatory? Oh no, lawyers, kill them. No. Precatory means you make incomplete gifts. Like if you write out your own will and you say, I give my house to my daughter, that would pass it. If it's signed, it doesn't have to be dated even. That would pass the house. However, that isn't the way people say it. They, you know, I like my daughter and I would like her to have the house. Boy, that's precatory. Precatory means it's incomplete. I would like her to have it doesn't mean I give it to her. To be clear, the statute requires you to make a completed gift, testamentary gift. You can set up a trust, a testamentary trust. You can set up a trust for people. You would not leave everything to little brother Chaffin right here, okay, for his new Corvette when he turns 18. No, you want the trust to be when he turns 47, he can have $1, okay? I understand that, you know, we don't want the kids to get the stuff too early. Plus, they don't know what they're doing. What's majority? When is majority under Texas law? In other words, when can you sign a contract? 18. How old?
18.
Yes, 18. How old can you be prosecuted for a felony? 17. So you can be legal criminally at 17 when you have no sense, and you can be legal on contracts, wills, trusts, stuff like that when you're 18. No sense. Okay, still no sense. When I was 18, I joined the Navy and I went into the Navy. Boom, because my mother said, well, don't you want to go to college? I said, I just graduated high school. I know everything, okay? I don't need to go to college. And so I went in the Navy, and after 6 weeks, I shined a lot of boots, okay? And it wasn't like this. It was, well, boom, that's what they did in those days when they cleaned their boots. And it was not illegal. Now, you might go to your union rep or something. I don't know. But boot camp in those days was really boot cleaning camp. But I tell you what, I learned a lot. Those 4 years I was in the Navy gave me a lot that I use till this day. Okay, it's like going on a mission twice. Okay, anyway, so wills and estates are very important, and too often people don't think they need them. Nah, I'm too young. I don't want to. Let's go through some of the steps of what I've seen over these many years, and some of the things that might be helpful. So I got it written up here. So we're going to go right into here. Okay, and I don't know if I'm gonna ask anybody else to read some, but maybe not. Okay, there are 4 basic documents needed for an estate plan for the average person in Texas. 4. Number 1, a will. Number 2, a living will, which we'll talk about each of these later. Number 3, a medical power of attorney. Number 4, a durable power of attorney. Well, what is that? Can't you just do it all in one document? I have people all the time ask me that. Can I just do one? I just came here to do one document. I don't want to do 4 documents. You're trying to gouge me out of some more money. You know, dang lawyers, I knew it. You know, lawyers, you go see a lawyer, they're going to try to rip you off. Okay. These are our 4 documents. Now, this is a will. Can everybody recognize it? What can you do with the will? You can do almost anything with the will that's legal. The reason I set this up like this is I show 3 generations. I show this generation, then I go down to another generation. These are kids, and who are these? Grandkids. Now let me tell you, what is the word that talks about these? Okay, what are these? Stirpies. That's stirpies. Not
Sturpies?
herpes, stirpies. Stirpies. When you do a will, you say, I give, devise, and bequeath all my property to my spouse. This assumes the spouse is already gone. But that's the way it normally goes. It's called a ma-pa will. I give everything to my wife. She gives everything to me. When we both go, then it goes to the next generation. But then, is that the end of it? No. Nowadays, we're living longer and longer. And you might have somebody down here who passes away before up here. What happens to this portion? What happens to that portion?
Children.
Maybe. If you say stirpies, it goes to the children. If you say per capita, it goes to the other kids. And you cut off grandkids. So you got to say that. You got to articulate it. Now, if you don't have a will, what does the law say? It says per stirpies, by law. Okay? It goes, if you have a kid, it goes down this way. And I'm going to show what happens when you have to do an heirship proceeding instead of a will proceeding. A lot more complicated, a lot more money for me. No. Complicated. A will, probative will takes about 4 or 5, maybe 6 documents. That's pleadings and things in court. An heirship proceeding can take up to 20 to 25 documents. Every time you add a document in a court proceeding, what does that mean?
Takes longer.
Take longer, but better than that. I mean, worse than that.
Money.
Money.
And time.
Money. And when you have an heirship proceeding, the court is going to think that you're trying to steal the estate, even if you're the widow. That's what the law presumes. It presumes that there's heirs out there that you're trying to cheat. So you have to delineate who are the heirs. And you have to have independent witnesses, and the court even appoints a lawyer called an attorney ad litem to fight you. And guess what? You get to pay them.
Oh.
How's that? Pay 2 lawyers. I don't even want to pay 1 lawyer. You have to pay 2 lawyers. So that's why a will is so important. Now, what can you do with a will? You can set up a trust. If you have little kids, you don't want to leave, ma, pa, but what if ma, pa go at the same time? Car wreck, airplane wreck, whatever. You have to name who's going to be the guardians of those kids. Would you like someone to be the guardian of little brother Chafin? The guy with tattoos? Like, oh, I'm sorry. It's okay to have tattoos, but not on the left arm. Just remember. Or somebody, you might have a brother that might do it, or a friend or a relative, and you don't want that person to do it because you know a lot about them, but you might want a sister to do it, or you might want an uncle or aunt or your dad, mom, something like that. You want to designate. In a will, you can designate who's going to take care of your kids if you're not around. Now, does the court have to follow that? If you put, doesn't have to. The court does not have to follow that. But the court gives great deference to what the person who was the most interested party in the life of that child making a choice of who's going to take care of that child. If I was a judge, I'd say, you know what? Sister Chafin said that she wants her dad, Clark, to be the guardian of this child if he's around. He's getting old too, okay? Like me, Clark and I were kind of almost same generation, but nevertheless, you'd like your dad, perhaps, if you want to choose that. All right, and who better can choose? The parents. Now, what happens so much now in our blended families and things of that nature, you can have a family split, and then there's the same kids. The same kids. You don't divorce the kids in a divorce. I do no family law. I will not do a divorce. I will do a capital murder case with a big smile, and I'll do it in a minute with no problem. But I won't do a divorce. In a divorce, it's never over. When's the divorce over? It's never over. And I remember when I was bishop of this ward, right in the manual, it said what? Do not ever counsel people to get a divorce. And more than once I wanted to say, divorce that sucker. But I follow the rules in the red book and the blue book. Don't do it. And you know what? It's right. It's not up to the ecclesiastical leaders to recommend a divorce. You get your counselor to do that. No. But you know, sometimes people need a divorce. Sometimes they do. But you know what the biggest issue right now in family law is? Not divorce. 60% of the parents nowadays are not married. 60%. It just went over that a couple years ago. That means 40% of the parents are married in America. So what do you do in family court now? What's the main litigation in family court now? It's paternity suit to get child support for the children. Okay, because a lot of times the guy doesn't want to pay anything, and also if he does, you go to family court and he might agree to, you know, DNA test and all that, and then he gets to visit the children. You know, if it was my kids, I told Sister Farrell, and we've had our 50th last year. I told her, if we ever get divorced, I promise you, I'm going to fight to tooth and nail that you get the kids. Okay. Anyway, we had 5. They're all grown up now, and that's not really true. We love our kids as you love your kids, but you know, when you have a family break up, you still love the kids, but the parents don't love each other anymore, and sometimes they hate each other, and they hate their lawyer. Okay? No matter what you do, the lawyer is messed up. I tried a case and actually to a jury and got, this is a long time, this is why I don't do it. I got custody of the children, I got child support, I got part of the 401k of the husband, I got the house, I got it, and the husband got to see the kids twice a month on the 3rd Wednesday, and then the 4th Saturday, whatever, something like that. And after it was all over, after the jury came back, because they get to decide, the standard visitation order says it's a lot more liberal than that. But they didn't do the standard limitation order. They actually followed things that I was arguing, that he shouldn't have that much more visitation until he spends a year taking care of his alcohol problem, you know, things of that nature. But anyway, at the end, my client looked at me, the lady looked at me and was furious. She says, "You lost the case." I said, "What?" You lost the case. I said, "What do you mean?" He gets visitation. I told you I didn't want visitation for him. I said, "Mrs. Elizabeth, you divorce your husband and he divorces you. There's no divorce but of the kids. It's not under the law." Let me tell you, to get your parental rights terminated is harder than any legal thing you'd ever believe. I did it one time on a horrible case where the father was a gangbanger and he was shooting heroin and all, and even then Judge Macias would not terminate parental rights until I put him on the witness stand, and he was doing horrible things to everybody, including the Judge Macias, who almost put him in jail. I said, "Judge, don't put him in jail. Just, you know, he owes $4,000 in back child support. Make him pay it or go to jail." And of course his lawyer's there too. Make him pay the child support, and then let's terminate him. He's not going to do any good for this little child. You've seen it now. I put him on the stand. Everybody got to talk to him. You heard what he said to you. It's in chambers, and the judge did. He said, "You have till next Wednesday to come up with $4,000. He got it. He found it because he was in joy, knowing in his own mind that he didn't have to take care of a child until they were 18. He didn't care about that child, and that's sad. The people that are hurt are the little children. Okay, so anyway, that's why I don't do family law. But on a probate estate, when you leave property to husband and wife, you probably know it's going to be taken care of. You don't leave property.
Location, Fox Islands, Aleutian Islands,
Sorry.
class, light, magnitude, 4.9, 10 minutes ago.
That's what I'm thinking about too right now.
Not earthquakes, you know.
Anyway,
Sorry.
parents are gonna take care of their kids. You know, I trust Paulette, she trusts me, we trust each other. But then if you're both gone, that's when it gets to be a difficult decision. Who's gonna take care of the kids and who's gonna want them? You know, who's gonna want those 8 kids? Mormon family, you know, regular Mormon family. Who, you know, so you need to discuss that with people before you write it in your will. Who's gonna be the guardian of the kids? Who's gonna be the executor? Because the will also lets you set up who's gonna run the show. It's called an executor or executrix. Trix is a female executor. That's all old language. I just say executor nowadays because of the unification of the sex language in gender language in the probate code stuff. So anyway, you pick who's going to run the estate. They're the ones that hire the lawyer. And too often people, when you do a will for somebody and then they pass away, their kids come up and they go like this. You did a will. You did a will and they died. Yeah, I'm sorry. But you know what? We still have to probate this will. Yeah, the will's not it's not worth even the paper it's written on until a judge blesses it, and then you have a court hearing that proves that it's done with the formalities and solemnities that are required to make a will, and that it's not a forgery. It wasn't created under duress, or when the time the person made it, they were 18 or older. You've got to be 18 to do a will, and you're sound and disposing mind and memory. Every time I do a will, and I did one today for a lady that was 85, I love doing them because I have to ask them, and I do it like this. Now tell me the truth. Raise your hand. Do you swear? You swear you're 18 or older? Is it? I'm going to card you, and they love it, and I love it too because they think, but it's statutory. How old do the witnesses have to be in the self-proven affidavit? 14. You can be a witness at 14, but you can't be a testator or testatrix till you're 18, unless you're emancipated. Is that what Lincoln did? Emancipated people for wills? No, you can be emancipated if you're done by court order. You can be emancipated at 16, 15 sometimes, 18, 17 and a half. Or if you go in the military. If you go in the military, you become emancipated. You become. All right, so that's what happens. So those things are in that self-proven affidavit. So it's not the will. The self-proven affidavit is not the will. It is a document attached to it that makes the will self-proving. Why is that important? Well, where are the witnesses if 30 years ago you did your will?
They're dead.
They're dead or they're gone for sure, right? Well, I had JAG do it. Yeah, who were the witnesses in the JAG will? They're long gone. And I get a bunch of those JAG wills. But they have self-proven affidavits. Sometimes we give seminars to the lawyers over there, the JAG officers moving through, to give them a little bit of an idea of Texas law. Because they are not from Texas often. And we have to teach them how to do Texas law. Because they'll do Sheboygan, Wisconsin law. Which, they might have 3 or 4 witnesses. At least you have to have 2 witnesses in a Texas will. Well, they might have 3. That doesn't hurt you. But what if you just have 1 witness and it's the testator? Not going to fly. And I also had a will where this lady went in with her kids and left the property to her kids and had her kids be the witnesses to her. Well, they know me better than anybody. Is what they didn't tell me, but the kids said, well, yeah, we knew, but you're the beneficiaries. A beneficiary cannot be a witness to the will that they get the benefit. Also, a lawyer cannot be the beneficiary of a will that he creates. They should go to prison if they do that. But it's been tried. There's a case out of San Antonio that is the classic ethics case for lawyers. It's where the lawyer did the will for a big estate, made himself the executor and the trustee of that same estate. Had over $1 million in fees in that estate. And then the people in the estate, like the kids and all that, they got attorneys that lied to them, and they sued that law firm and won. And they won like treble damages. So they put that law firm out of business. It was a big law firm. But just think about it. Do I need to go to ethics school to know that there's something wrong with that? Set myself up as any kind of a beneficiary of a document I create? I can bully people into doing that, can't I? Like a doctor that does a lot. I sued a doctor in El Paso when I was with the Attorney General's office that was doing births. He had a little birth hospital, but he did them all C-sections. Everybody needed a C-section. Why? The regular birth was $300. The C-section was $2,000. Everybody needed a C-section. So I subpoenaed his books, and we got them all down there, and got an injunction on him, and other things too. And back then I was young. I was young, and I thought I was powerful and all that. And when he threatened to kill me, I thought it was a joke. Till the gun clicked 2 times. No, he didn't use a gun. He did go to prison on other things. He was doing abortions also. Besides, he was doing abortions, and actually, one of the nurses saw him doing some third trimester abortion, where the child was born in vivos. In other words, you cannot do an abortion if there's any movement of a fetus once they ex utero, and there was movement, and he this I'm not going to talk about it, but he went to prison for that, and he should have been. But I sued him under the Deceptive Trade Practices Act, because I was a prosecutor for consumer protection, and I said mothers of maternity services are consumers. So that DTPA, that very powerful law that helps you when you buy a car, whatever, helps you when you buy a doctor's service too, if he lies. You cannot sue for malpractice under that statute, but you can sue for misrepresentation and for unconscionable activity. Okay, so way back then. So when you're doing your wills, you have to have clear thinking about it. Think about it before you go see the lawyer. I've had people come in there and we start talking about how to do a husband and wife, and it's normally second wife, okay, second husband. We start talking about it, and they everything's fine about how the property's going to go, as long as everybody's kids from the prior marriage are taken care of. But then they start saying, who's going to be the fiduciaries, the executrix, the executor, the guardians? And I had a man or woman that came in my office and almost had a fist fight, okay? And so, I said, well, you guys better go home and think about this, But here's the questions. 1, 2, 3, 4. Never came back. Never came back to see me. All right? So, think about what you want to do. The questions are these. How do I want my stuff left? I mean, stuff is important, but what's more important is how do I want my kids taken care of, and who's going to manage this? So, you think about that first. Now, per capita and per stirpes, you want your grandkids to get the 1/3. If this kid dies, you want the grandkids to get it? What if they're 8 and 9 years old? You're gonna have to set up a trust for this level. You can do it with a document. You can set up a trust. If everybody's an adult, you don't need a trust.
Earthquake upgraded to 5.2 from 4.9. Location, Fox Islands, Aleutian Islands. Class, moderate,
Can't turn
19
off the
minutes
light.
ago.
I'm glad I'm not in the Aleutian Islands right now.
Yeah, it's pretty strong.
I want you to see this. How to live and die with Texas probate. This is how property passes when you don't have a will. This is community property. This is separate property. Who wants to do one of these? They're wonderful. Your lawyer does this for you. How many documents am I going to need to get this thing done? What is community property? What is it? Everything is presumed, even if it's not got together. Everything is presumed to be community property if you're married. Okay? Like I have a bank account with $10. She's been eyeing it for a long time, but hers is $20, so I'll share it. But let's say I have a bank account with $10 in it before I get married, and then after I get married, I have that bank account with $10 in it. Okay, and then we have a problem. We need to decide whose $10 is it. It's still mine. It's my separate property. If I keep it in that same bank account that was created before the marriage, okay, that's separate property. That's this side. What about this? I have a bank account with $10, and she puts her $5 in it. Well, then only half of it's community property, right? Or only 1/3, 2/3. No. Once you commingle a separate asset with a community asset, they both become community assets. So if you have bank accounts that are just in your name, and your spouse has a bank account that's just in her name that you had before marriage, they will remain separate property unless you commingle. So that's important to know. When you try to do one of these, all these are contingencies. This is this and this. Now, an heirship proceeding is this. An heirship proceeding is when you don't have a will and you want the property to pass. Like husband and wife, you want mama to get the house. That's 99% of the cases. Mom gets the house. Well, is it her house? No. No, half of the house is hers. Half of the house is hers. The other half belongs to the spouse that died. Now, they changed the law about 15 years ago to say if the kids are the same kids for both husband and wife, and there are no other kids, then it does go to wife or husband. They changed that. It used to go to kids. Now, what about this? You have one kid from a prior marriage or an illegitimate child, then it goes to the kids. Community property goes to the kids. So here you are in the house. Theo had a little girlfriend and whatever, and before he met you, and he has a child there, and then you have 4 children with yourself and your husband, he dies. Who owns you buy a house together, you own half the house, who owns the other half of the house? All the kids. Your kids and that other kid. That other kid is the one that brings it into an heirship proceeding, that all the kids own the community property. This half goes to the kids.